I will now deal briefly with employment law in Malaysia. I'll just give you a general overview of employment law in Malaysia. In Malaysia, employment law is primarily governed by our Employment Act 1955, as well as our Industrial Relations Act 1967. There are, of course, other subsidiary legislation and regulations, but the two primary legislation, the two main acts in Malaysia governing employment law is the Employment Act 1955, as well as the Industrial Relations Act 1967. Dealing with the Employment Act 1955 first, this is an act which has been implemented to protect employees by ensuring that there are certain minimum standards in the conditions of employment which are maintained by the employer. For example, this act will ensure that employees are properly paid, they are paid their wages. It imposes restrictions in the deduction of wages. So once you employ a person under a contract, and say, for example, you offer the person a monthly remuneration of 5,000 ringgit, the employer then cannot just unilaterally reduce that person's wages to say 4,000 ringgit a month. In such a situation, the act will come into play and it will offer protection to the employee. The employee can then seek appropriate remedies under the law, under this act, should the employer make unilateral deductions in terms of wages. And of course, it provides other protections to the employee as well in terms of your leave, your maternity and entitlement, and etc. But there is one thing that you need to bear in mind. This is very, very important. The Employment Act 1955 only applies to employees who earn RM 2,000 a month or below. This is set out in the first schedule of the Employment Act 1955. So say, for example, you're an employee earning 5,000 ringgit. Are you protected by the Employment Act 1955? Generally, no. If you're an employee earning, say, 1,800 ringgit a month, are you protected by the Employment Act 1955? Yes, you are. So what happens to employees who earn more than 2,000 ringgit? If you're not protected by the Employment Act 1955, then what protection is provided to you? Well, for employees who do not fall within the ambit or the purview of the Employment Act 1955, their terms of employment, their employment with the employer, with the organization, will be governed by the terms of their employment contract. So for all of you who are earning more than 2,000 ringgit, your terms of employment, your conditions of employment would be governed by your employment contract. That would be the key document. That is the fundamental document which would set out your terms of employment with the employer. Now, dealing with the Industrial Relations Act 1967. This act governs, similar to the Employment Act 1955, it governs employment relationships in Malaysia. But this act is designed to provide remedies to employees who have been unfairly dismissed or who have considered themselves to have been constructively dismissed. And it also provides rights and remedies for trade unions. And there are also provisions relating to collective bargaining. So if you're a large organization which has a trade union, the rights of the trade union are governed by the Industrial Relations Act 1967. And the whole purpose of this act is basically to promote and regulate the relationship between an employer and the workman and the employee. And also, if the organization has a trade union, to govern the relationship between the employer and the trade union. It is also an act designed to cater for settlement of disputes. So for example, there's a dispute between the employer and employee relating to their terms of employment. There are provisions in this act which provides solutions for such disputes. The fundamental aspect of this act, the Industrial Relations Act 1967, is to provide a balance between the right of an employee to their livelihood and also the right of an employer to dismiss or terminate an employee in justifiable circumstances. Now, ladies and gentlemen, it is important to note that A person's right to employment is a fundamental right provided under our federal constitution under Article 5 brackets 1. And this has also been set out in the landmark decision of R. Ramachandran against the Industrial Court Malaysia and another. Basically, every person who is gainfully employed also enjoys security of tenure. And in the event there is an encroachment, there is a breach, an employee has been unlawfully terminated from his or her employment, then that person can seek appropriate remedies for wrongful dismissal or statutory unfair dismissal. And in Malaysia, when an employee considers himself to have been dismissed without just cause or excuse, without a valid basis by the employee, without a valid basis by the employer, the employee then may make a representation in writing to the Director General of the Industrial Relations Department under Section 20 of the Industrial Relations Act 1967. So basically, as an employer, it is very important for you to take note that a person's right to livelihood is provided not only under our statutory laws, but it is also provided under our federal constitution. And the acts that have been implemented, such as the Employment Act and the Industrial Relations Act, have been implemented to cater for situations where this fundamental right is breached. So always be very, very mindful of this and be very, very careful when dealing with an employment contract. Always ensure that the rights of the employee are protected, and the right to terminate an employment contract is only exercised in circumstances justifying such termination. I will deal with that later on in my presentation. And now, in the event an employee or person's right to livelihood is infringed, as mentioned earlier, the employee or the person can make a representation in writing to the Director General of the Industrial Relations Department for unfair dismissal or wrongful dismissal. And a person who pursues a claim for unfair dismissal or wrongful dismissal is entitled to certain remedies provided for under the law. There are 3 fundamental remedies provided for under the law. The first remedy is the right to reinstatement. A person who has been unfairly dismissed can seek reinstatement to his or her former position with the company. So for example, you are a general manager with a company, you have been terminated by the organization, and you feel that you have been wrongly terminated. You bring a claim for wrongful dismissal, and your claim for wrongful dismissal is upheld. You can then seek reinstatement to your former position. You can seek to be reinstated to the position of general manager with the company. Apart from reinstatement, a person or an employee who has been wrongfully dismissed can also seek compensation in lieu of reinstatement. And this is the remedy that is usually granted. Very rarely do the courts order reinstatement. The courts would usually order compensation in lieu of reinstatement. And the quantum of compensation that will be awarded will be will be based on the number of years the employee has been continuously employed. So for example, you are an employee who has been employed for 10 years by a company, and then you have been terminated. You bring a claim for unfair dismissal. Your claim is upheld. The court finds that the employer had wrongfully dismissed you. The court can then order compensation, order the employer, order the organization to pay you compensation. And if you have served the company for 10 years, you are entitled to 1 month salary for each year of service of your last drawn salary. So if you have served 10 years, you are entitled to 10 months of your last drawn salary. So the longer a person is employed, the more the more compensation they are entitled to. And apart from compensation, an employee who has been wrongfully dismissed is also entitled to back wages. Back wages is also a form of compensation which covers a specific period. It covers the period from the date of your dismissal until the conclusion of the hearing in the industrial court, or until an award is handed out, up to a maximum of 24 months. So this is just the overview of some of the remedies that an employee who has been wrongfully dismissed is entitled to if he or she is able to prove a claim for unfair dismissal.